Chief, can you hear me? It's 5 past the
Yeah,
hour. All right.
yes.
Okay, cool. So, hello and welcome, everyone. And we are delighted to have you here as Chief unpacks his critical review of the cross-border insolvency framework. The presentation today forms part of his, or will talk to us about part of his recently concluded thesis, which is titled Blazing the Trail in the New Governance, the Role of INSOL International in Shaping the UNCITRAL Model Law on Cross-Border Insolvency, 1982 to 1995. I will start with some light housekeeping. For those of us that are For those joining us for the first time, please note that we like to keep a warm, engaged atmosphere at our CLRNN Spotlight, which is where we talk about issues relating to corporate governance and insolvency across Africa. To enhance the interaction between participants and speakers, we style our events as meetings, which means that you can mute and unmute yourselves. So please ensure that you mute your microphone upon entry and that you keep the microphone muted whenever you're not speaking. And please note that if you're dialing in with a phone, when a call comes through your phone, it triggers the microphone for your Zoom account, and it means that we're going to start to hear whatever it is that you're saying. So please bear that in mind. We actually love to see your video feeds, so we would be delighted if your video feeds were switched on throughout the event. Usually at the end, we stay on for some time for people to come on and chat to one another before we cut out the feed. The order for today is usually in the pattern that the presenter would speak for 30 minutes while the discussant would respond for 10, maximum 15 minutes. Right after that, there would be a question and answer session, and we encourage people to either use the raise a hand function on YouTube, on the Zoom page, or they can put the question in the chat and we'll read the question out to the speakers. Well, we record our sessions and we share these via a YouTube link, so bear that in mind as well. And with that, I would just introduce our speakers for today. Our main speaker is Chief Anthony Idigbe, who I really should say requires no introduction, but because we tend to have people from different countries participate at these events, I will introduce him. And our discussant today is Mr. Stephen Kargman. So Chief Idigbe is the senior partner at Punuka Attorneys and Solicitors, and a leading insolvency and commercial firm in Nigeria. Chief Idigbe SAN has over 35 years of experience in practice in various areas of law, including privatization, capital markets, mergers and acquisitions, as well as insolvency law. He's widely consulted by governmental agencies in Nigeria, including the Bureau of Public Enterprises, the Securities and Exchange Commission. He's consulted by leading banks and businesses. Well, Chief Idigbe, for all those who know him, is a scholar. He soaks up knowledge. He loves to engage in theoretical issues as well as the practical side. He recently completed his PhD, which he will be discussing today, at Osgood Hall Law School at York University. And we all know that he participates assiduously in capacity building. He has formed, led, participated in various associations and bodies across the globe. And one of them is the subject of his study today, which is INSOL. Now, our discussant is Mr. Stephen Kargman. He is the founder and president of Kargman Associates. They are international restructuring advisors in New York City. They specialize in providing strategic advice to clients involved in complex and challenging international restructuring, cross-border insolvency, distressed debt, and non-performing loan situations. And they have a special focus on emerging markets around the globe. Mr. Kargman is a leading expert on international debt restructurings and international insolvency. He has worked on numerous high-profile and complex restructuring transactions in emerging markets. He's also advised on multilateral institutions and national governments in emerging markets and developing countries on a wide wide range of financial and commercial matters. He also, like Chief, has a huge thirst for knowledge. He teaches on insolvency law when he has some time. He's published numerous articles in leading professional journals on topics related to international finance and international restructuring. He's a founding member of the International Insolvency Institute. He's a member of, he's been a long-time co-chair of the Sovereign Debt Restructuring Committee. He's served as a member of the US government and American Bar Association delegations to the United Nations Commission on International Trade Law Working Group on Insolvency Reform. Well, he will today focus mainly on Chief's presentation because we have not required him to read the 300 odd pages that make up Chief's dissertation, but we're sure that we're in for a very interesting time. And with that, Chief, I hope you've cleared your throat and got yourself a cup of water. I pass on to you.
Thank you so much, Bolanle. I'm humbled by that introduction, which I probably don't deserve. But I would like to share my screen, if you don't mind, as I would follow my presentation on the PowerPoint. I hope it is clear enough. Okay, so I'll be talking about cross-border insolvency and global norm-making. The discussion is based on the paper, the dissertation which I did at Osgoode Hall Law School, which is part of York University. And Bolanle has already told us the topic of that dissertation, which is the norm life cycle theory and the role of INSOL International in shaping the UNCITRAL model on cross-border insolvency, 1992 to 1997. Hopefully, I would talk about the motivation for the study. I'll talk about why cross-border insolvency, then I'll delve into the thesis of that dissertation. I'll talk a little bit about international law and global norms, the global norm-making process, and then zero in a little bit on cross-border insolvency norms. And then I'll talk about the findings and conclusions of the study, as well as the lessons for the global South. So in terms of the motivation for the study, I was involved with BRIPAN, which is the Business Recovery and Insolvency Practitioners Association of Nigeria. Initially, I assisted them with Sonali Abiratne of INSOL to develop a curriculum. And then I later became the president of the organization. I was part of the group working with people like Sheyi, that instigated INSOL and the World Bank to start the African Roundtable. Also, I worked out when I was president to obtain UNCITRAL Working Group 5 observer status for BRIPAN, and then attended some of those sessions in New York and Vienna. I also did the INSOL fellowship. So these things led to a certain intrigue about the role of INSOL, which is a non-state entity in the making of the UNCITRAL model law on cross-border insolvency. And of course, my observations of the dynamics at the Working Group 5 sessions which I attended also stimulated my interest in this subject matter. So why do we need to regulate cross-border insolvency? Of course, when multinational enterprise groups collapse, it has implication across borders. I mean, in terms of assets, in terms of debtors and creditors. So different laws will apply in different states where they have assets. So you look at Nortel case, for instance, which was a Canadian group. If you take Apple today, Apple has capitalization of over $2 trillion. And you can imagine that is larger than that of probably all the African states together. And if it were to collapse, you can imagine what the impact will be in terms of assets. So you look at Parmalat, which was the Italian group, with implications all around the world. And then you look at, say, Lehman Brothers, that had a big impact in the financial sector, leading to collapse of several other financial institutions. So the thesis which I tried to pursue postulates that there's a direct relationship between the level of contestation and engagement of states and non-state entities and the global norms that emerge, cascade, or become internalized as global norms. So that's what I try to look at. Is this true? Is it true that there's a direct relationship between the level of contestation and engagement and then the norms that emerge? Of course, who are the states or the non-state entities that are engaged in this contestation? You would find that there's an organization like INSOL International. You have IBA, International Bar Association. These are non-state entities. Then you have states like the United States, which most people know as the norm leader. You have the Hague Conference, which is a meeting that takes place. It's a multilateral group, Eurocentric, that based in the Hague, that also sort of like come up with norms or treaties. And then you have UNIDRA, which says it wants to write the laws so that the laws are known, and then they bring in professors, mostly Eurocentric, to try and harmonize between civil and common law traditions. And then you have the United Nations, which is an assembly where you have states, particularly in the era of the emerging developing states or global south, all coming there to contest. So when you look at the issues in terms of international law and global norms, you find that international law is actually developed from the concept of no man's land. In other words, that a state is sovereign within its own state, its own territory, and then can pass laws within its territory, and no other state can come within its own territory to tell it what to do. But outside its territory, it can do anything. So everywhere is regarded as no man's land. So you have piracy, you have colonization, once it's not your territory, you can do anything you want outside. So, but the unbridled sovereignty or exercise of sovereignty outside territories led to contestation and conflicts between states. And then the states tried to moderate this conflict through treaties. And if you look at this leads to sort of like a conflict between the classical international law, which says that states are sovereign and then they can only reduce their power through treaties. That's classical international law. And then modern international law, which says no, it's not only through treaties that you can reduce your power. And what then happened is they created what we call multilateral institutions like, United Nations, World Bank, UNCITRA, etc. And these international institutions are made up of bureaucrats who came initially from the states, but now who are sort of like independent source of power, not depending on treaties, but agreeing on norms and rules, and basically the states have to comply with what they do. Classical international law practitioners or theorists would are against the whole concept of modern international law and international bureaucracy, etc. And again, if you look at classical international law, which is based on the rational exercise of power, it goes against norms which will be socially shared values. So states would act on their own, based on their own rational self-interest, and not based on any shared norms that they enjoy or they share with other people, which is not punished by any rules, but just by, say, some social event like ostracization, etc. So you have this set of thoughts around norms, which is led by the constructivists, who argue that you can have socially shared views, beliefs, and these socially shared beliefs actually influence the law, what the law will be, etc. And then, of course, on top of all this, you have the TWAL movement, which is the third world approach to international law, which observes that there is a sort of like a gap between the more powerful states and the less powerful states, and that the entire normative system is geared towards protecting only the interest of the more powerful states. Now, I think the question is whether there is any convergence between these different levels of thought, you know. But in terms of global norm making, there's no doubt that most of the norms that are generated are dominated by the new liberal capitalism. So it's always about, trying to protect capitalism, profit, rights to property, etc., and then protect it across border. And that is what has always influenced the norms that are developed. Again, that goes to, if you take the TWAL approach, to protecting the interests of the more powerful who have property or have credit, have assets abroad, and have businesses across border, etc. Now, then you have the norm life cycle theory, which was developed by Finnemore and Sekik, where they say that, norms actually do not enter a normative vacuum, and there will always be some other norm that is existing before a new norm will come up. And that what happens is that the norm has to emerge not into a normative vacuum, and therefore there has to be a contestation with existing norms, sort of like bouncing of all the norms, and then somehow one will emerge and then cascade to becoming accepted socially, and then from there it will become internalized. So that's the theory, the frame that I prefer to use. I prefer that to the TWAL movement, and of course, in between, there are new things that have come up, like the pandemic, in terms of what's the effect of COVID pandemic on global norm making. It comes in tangentially in the study that I did, and I would talk about it because it provided some solutions. So the study actually does some historical analysis in terms of global norms, looking at global norms, either from the institutions that were involved or from the time horizon. So again, you can generally divide the norms into two in terms of the institutions, either state institutions or non-state institutions, such as INSOL. And I did, I went down the time horizon, and I tried to look at insolvency from history. How was cross-border insolvency resolved from history, historically, and what role did non-state entities play in that? In fact, what I found was that mostly states were not sufficiently involved with cross-border insolvency. It was mostly non-state entities that were involved. And the involvement of states in cross-border insolvency is extremely recent, historically. And usually the traders themselves regulated themselves. And so they had all sorts of different concepts. In Europe, for instance, you were encouraged to flee abroad, and when it started in terms of bankruptcy, it was about actually, it moved from the sharing of the body. So if you are owing people, they basically killed you and shared your body amongst your creditors, you know. So it moved from Roman times of sharing of the body to sharing of the property. So instead of sharing the body of the person who is owing, because it was, the point is that owing was inalienable. In other words, you can't come out of the fact that you are owing. So if you can't pay, basically they kill you and share your body. And then they moved to, okay, no, we don't need to kill the person. So why don't we share the person's property? So they share your property and then you have no chance. And then it moved from that to the concept of being able to discharge the person, share the person's property and let the person go, particularly if it was not the person's fault, it was just a market-driven situation. And then to the American liberal attitude of giving the person a second chance, you know. So you see that history going on, and you see where even when they started giving option of discharge and the rest, they didn't really extend it to non-traders. You have to be a trader before you can enjoy even a discharge, to extending it to everybody, etc. So it's involved, and then in more recent times, we find that the non-state entities, I mean, if you then look at the time when when the state got involved, mostly through the UK, where they started appointing official receiver, what you call officialism, and then the state got involved, not just the trade association. And then there are periods of when state got involved, state went out, and then state got involved again in managing insolvency, and which is what we have today. And then you see within that period where associations got involved first, as they were reforming the company law in the UK, they required companies to have statements of account, and therefore accounting bodies became important. And then the lawyers became important because you could get a discharge, but it was a legal process, so you have to go to court. So you see a lot of the initial organization or the non-state entities was around the accounting profession growing in UK and the legal profession growing in this area. And then today, that transforms to, on cross-border basis, they kept looking for which platform to use internationally. And then you had the IBA and you have the INSOL. So a lot of shifting plates, lots of problems around the growth of cross-border insolvency. So you then have these two organizations that I saw were battling to be the ones that are determining the norms internationally today, now back to modern times. INSOL on the one hand and IBA on the other hand. IBA was pursuing the concept of a model law on International Cooperation Act, which is based on a US concept of one court, one jurisdiction, centralized determination of the rights of parties in a cross-border insolvency situation, basically trying to extend Section 364 of the Bankruptcy Act of the US. And in that context, in the ICC conference of 1925, the US delegation supported the idea of a convention. The same thing in the 1939 conference, ICC conference. So that has always been the same position. And all the initial studies that took place, like the one by Getlin and Meyer around 1979, were funded by the IBA. And so the IBA was the leader. And then when they had the 1992 Congress of UNCITRAL, where UNCITRAL was trying to look at what new jobs they would do, and they invited the IBA. And the IBA was represented. They made the main keynote address, and they came up again with the idea of harmonization and convention, etc. But it was at that was what triggered INSOL to engage with with UNCITRAL. At that stage, they realized that maybe the norms that would come out may not favor them as practitioners because they represent practitioners. And so one of the why question was, why did INSOL emerge as the norm entrepreneur? and why did they pursue what they were pursuing. I've tried to identify them here, the why, high taxes and fleeing debtors in the UK. So they were trying to locate those debtors, negotiate with them abroad. Most of them had gone to the tax havens, etc. Then there was a collapse of the command economy in the UK. Then there was globalization happening at the same time. So people having more assets abroad, but their clients were suffering hardship. I'm talking of the insolvency practitioners trying to recover abroad. And then there was the issue of the leadership in the US and the UK being able to cooperate. They started the conference meeting of the two groups between the UK and the US. They brought in Canadians and Australians as the initial people, and then developed relationship among themselves, set up a management structure, membership offering, had specialized groupings, and they had good knowledge. Then they started contact and references to enable them cooperate, because they were looking for insolvency practitioners abroad who could assist. And that's how the initial idea of just cooperation and coordination came up, that norm. It came out from their practice, from what I've seen. And I did discuss some of the theories, because in the course of this work, the question was, does INSOL actually have a norm that requires cooperation, and the truth is you can't find any norm specifically, or any rule, any formal rule. But Professor Boggin, in one of his studies, showed that you don't have to have a rule, that your practice can generate the norm. And he did a study in the context of human rights tribunal decisions, and how the decisions now influence the practice and what states do. So the same thing is applicable. And then that practice, which of cooperation amongst themselves, led to the Maxwell Protocol, which I consider the climax of the norm of cooperation and coordination. Of course, there is norm contestation, because, there were other norms, as I've said, like the IBA norm and the position of the Americans. And so because there was that norm contestation, and INSOL knew about it, INSOL applied these Chatham House rules. There's certain sort of secrecy. They don't discuss a lot of the issues, and then they allowed the Americans to lead. They courted the Americans being the norm leader. And they also courted UNCITRAL as a platform, and they courted judges, etc. Now, in terms of how did I arrive at this, these are the things that I evaluated. I looked at memoirs and the reflection of members, a lot of writings from INSOL members, journal articles, website review. I looked at legal records, reports, studies. I looked at the proceedings, transcripts, reports, working papers. There was also a valuable journal, the INSOL World Silver Jubilee Edition, which I reviewed, and I was able to get all this from many of those sources. And I should say that, just to mention that my study was social legal. It was not doctrinal, so it was a social legal study. In fact, even the theory I'm using is from, what is it called? From human rights. So then I looked at the how did INSOL persuade UNCITRAL and the delegates to adopt the modern law approach? So this is the how. I don't need to repeat the how. I have these slides, and it can be made available. But they deployed socialization techniques, and these are the things that I evaluated, to be able to determine how. I did an elite interview, so it was a mix. If you look at my study method, I looked at historical data. Then I looked at existing interviews, because luckily there were lots of interviews that have been granted by many of the leaders that are publicly available. And then I did a fresh interview on selected people, with selected people, then did contextual reconstruction of what happened. So it was a legal history method that I used to be able to determine the how. So this, for instance, this data presentation where I did analysis of contributions at UNCITRAL showing that high GDP states made the most contribution, and then the low GDP states just sat in and they don't really contribute a lot. And I showed the contribution of the international state entities like IBA and INSOL, and then the UN itself for UNCITRAL. And one of the arguments I made was to try and track, norm definition and how it changed over time, and track the performance of these different groups. And you could see that UNCITRAL itself didn't have a lot of knowledge at the beginning, but towards the end, towards 1997, between 1992 and 1997, they had become known as experts, and they really spoke with authority when they attended meetings. So INSOL achieved one of its objectives, which was to actually make UNCITRAL to be the voice, whilst they stay at the background. Because remember, there's a norm contestation. If they come out too much, other people attack them, whether it's the American group trying to say that they are the ones in charge, or IBA trying to say that their own norm should be carried. In fact, the IBA delegate in the interview that I had with him said, well, we see Nick Cooper around, but I don't really think they contribute much, right? Because the debate on the floor was what determined what the norm was. But I was able to show that that was part of the strategy of INSOL to be low, but that if you looked at the outcome of the outcome of the law, the model law in 1997, and compare it to the draft that was prepared by INSOL in 1994, there's not much difference. So the what question is how the internalization, which is the third stage, I looked, this is how they internalized it, and then these are the things that I evaluated. But some of the things that came out from it was that adoption rate was low, particularly among low GDP states, and I tried to show that there's an assumption that in the norm-life theory that it's an irreversible growth from stage to stage, from emergence to cascade to internalization. But I found that there is a reflexivity where, the internalization state can be affected by participation at the emergence stage. And that, particularly when you look at it in terms of the low GDP states, because they didn't participate at the emergence stage, it was difficult for them to adopt. And also it didn't really meet their needs, because most of them didn't have a good insolvency system anyway, not to talk about credit system. They didn't have a developed economy, so they were not generating assets abroad. And therefore, what was the use of the model law to them? And then you take the example of Eritrea, which was the first country to consider in 1997, immediately after the model law was adopted. It was trying to amend its law. And then they got some American professor who did the amendment for them, and then they never adopted it. And then he wrote something about it and said the reason why they didn't adopt it, that they became afraid and said, oh, if we adopt it, it will be easy for people to come and recover assets in our country. And we are likely to be the victims because we don't have any assets abroad, and our people who go abroad to get to have assets may run into trouble when they come back to our country. Then it will be easy for those pursuing them, like the receivers or liquidators, to get them here. So they refused to adopt it till today. But they were the first to amend their law, or try to amend their law. So that gives a very interesting idea of the tension between the different issues, and that the norm-life cycle theory, why it's very good to explain the life history of a norm or the life cycle of a norm, does not fully explain everything, because there are so many other tensions which are raised and explained maybe by epistemical community concept or the toal concept, etc. So what did I conclude from the study? First is that the origin of the invention of the model law is not UNCITRAL. but INSOL. I make the definitive finding that it is not UNCITRAL, but INSOL. And I say that if you look at the Ron Hammer expert report and the judge's evaluation, this took place it was presented in 1995 at the Toronto Judicial Colloquium. You look at the introduction document at UNCITRAL when they started the discussion, because that introduction document says, well, look at this. We are attaching to you with this notice, this agenda, the expert report, the judge's evaluation, the outcome of the report of that a joint conference by UNCITRAL and INSOL. You would, and when you examine it, you will see the correlation between the initial input of INSOL and the final model law output. And many delegates change their mind, their position on norm definition from the model insolvency corporation of convention of IBA to the model law approach, including the US delegates, etc. So there was also a misconception that the objective of model law is harmonization. Actually, its objective is limited cooperation and coordination, with harmonization as a desirable consequence. And then the lack of internal consistency in its adoption is understandable, though it hinders non-diffusion. And adoption rates have not grown significantly compared with treaties. That's another finding. And the critical mass of states with high GDP states have adopted the model law. Participation in norm definition during Working Group 5 was dominated by high GDP states. Even the high GDP states who have not adopted the model law have similar norms of cooperation and coordination in cross-border insolvency. Now, other things that I found is that INSOL leadership is dominated by members from high GDP states, and I did the analysis, whose delegates also dominate participation at the Working Group 5. And low GDP states are not adopting the model law at the same rate as high GDP states. And low participation levels at UNCITRAL may have affected the level of familiarity and therefore adoption. And so the implication is that there's need to overcome the obstacles to participation at leadership levels of INSOL and UNCITRAL for emerging state members. And I argue that there is a balance between participation of non-state entities and UNCITRAL output, and that because it improves the legitimacy of UNCITRAL and its accountability. Some authors have argued that the meta bargain of UNCITRAL is the fact that it allows non-state entities to participate and giving it legitimacy. But I argue that is actually, ineffective, because the same power imbalance that exists in UNCITRAL also exists within INSOL, and therefore, even though UNCITRAL may say that there's a meta bargain in allowing a non-state entity like INSOL to participate, it's not really filled up because you don't have the representation of the global South sufficiently in INSOL. So the life cycle approach, however, is applicable to explain the success of INSOL in cascading the norm of cooperation and coordination at UNCITRAL leading up to adoption. And a strategy is not combative. Remember that if you look at other studies, there are some more combative ones. Like if you take the human rights area, you have those who are pursuing conservation. They basically fight forestry, deforestation, etc. And they fight physically. They actually go riot, demonstrate, etc. And then even they have achieved influence using that method, including different arrangements they arrive at through reporting arrangements, certification arrangements, etc., that have created new private norms, in that area. But the strategy of INSOL is completely different. It's not combative. It's more of socialization, etc., as I've identified.
So Chief, if we could wrap up based on that.
Yes, just 1 minute. Yes, so I will just conclude by saying, what are the lessons for low GDP states effective participation in global norm making. I think there are lessons to be learned from the technique, the non-combative strategy of INSOL. It can be used to influence norm leaders and then get the norm leaders to convince norm followers through socialization. Now, there are certain impediments that low GDP states have, such as cost, ability to travel to New York or Vienna. Some of the lessons from COVID-19 is that UNCITRAL is now doing virtual proceedings, etc. So we should fight for that to be sustained and not to be suspended after COVID, so that it will be cheaper for low GDP states to participate. And of course, we should be sharing knowledge such as what we are doing. And we are trying to campaign for INSOL to make its archives public, and then to increase participation in leadership in organizations such as INSOL. Thank you very much.
All right, thank you very much. Mr. Kragman, over to you. Well, given that Chief has overrun by about 5 minutes, I'm going to have to nick those 5 minutes off you. So if I could invite you to, okay, I'll nick 3 minutes off you because you look so surprised. If I could invite you to compress your response a bit so that we would have a bit of time without overrunning. That works? Still
muted. Yeah.
Okay. Thank you very much, Professor Adebola. And it's a pleasure to be with you and your colleagues from CLRNN and to have the opportunity to comment on Chief Idigbe's presentation. As you mentioned in your introductory remarks, I won't be commenting on the dissertation per se, because I was just called into this at the last minute. So I'm going to focus on the content of Chief's presentation. Of course, Chief is to be commended for a very comprehensive undertaking here, and very thorough and very broad scope, and provides a very interesting and thought-provoking analysis of key issues related to the topics under discussion. I want to make several points regarding the approach that Chief has taken. First point is his research underlines the value of sociology when considering the development of legal norms. The Chief predicates his analysis on what he calls the life cycle theory of norm development, and that provides an interesting lens through which to look at how the model law came into being. His concepts, the concepts of that he talks about, emerge, cascade, and internalization. Now, there have been prior efforts in this international cross-border insolvency area to apply sociology of law. And for example, Terence Halliday did some important work on this and wrote a book, Bankrupt Global Lawmaking and Systemic Financial Crisis. And so this approach, sociology of law, is it's a very useful tool. And actually, it would be interesting to compare how the analysis under Chief's approach compares with the analysis under Terence Halliday's approach. Now, of course, Halliday's had colleagues, Bruce Carruthers, Professor Susan Block-Leib, and so forth. So first point is the value of sociology in understanding some of these issues. And speaking of interdisciplinary focus, it might even be interesting to look at how political science, and particularly political economy, would analyze some of these issues. Now, second point is chief focuses on the role of INSOL. So therefore, he's focusing on what he calls non-state actors. I'll refer to them as non-governmental organizations. And I think that's a very useful focus because the NGOs, whether it's INSOL or International Bar Association or American Bar Association, they've all been very involved in the UNCITRAL projects on insolvency law. I first became involved after the model law when they were doing the legislative guide. So I've seen the NGOs' participation in that effort. And one point that's often overlooked is that the NGOs, while they sit in the back of the room at UNCITRAL and the state delegations sit in the front, when it comes to a very technical area like insolvency law, the NGOs can provide a lot of supporting information, technical expertise, if you will, for the state delegations, because the NGOs include practitioners and people who are actually handling the cases. Third point I want to make is something that the chief points out, but a lot of this focus, as far as I understand, on cross-border insolvency grows directly out of experiences like the Maxwell case, which involved UK and the United States, and the effort to coordinate the proceedings in that large corporate debacle. And so that provided an important impetus for an undertaking such as the Model Law Project. I should mention that, as in so many things, individual personalities affect the course of events. And here, there were two outstanding judges on each side of the pond. In the US, Judge Tina Brosman, and in the UK, Lord Hoffman. And so they were two terrific judges who understood the significance of these cross-border issues. And Judge Brosman, for example, appointed an examiner to help coordinate these proceedings. That was Richard Gitlin. A fourth point I would make, and I know I have to rush through these because we're limited in time, but UNCITRAL wanted, and the state delegations, they wanted to start small. In other words, work on a procedural instrument in cross-border insolvency, such as the model law, as opposed to undertaking and trying to develop a substantive instrument, because they realized it would be much easier to achieve consensus on a procedural instrument as opposed to a substantive instrument. And later, of course, they did undertake the substantive instrument, legislative guide on insolvency law. But the model law experience laid the groundwork for the legislative guide. It demonstrated that delegations, state delegations with different legal traditions, different legal systems could work together to develop an incredibly important instrument in cross-border insolvency. I should mention, just looking at UNCITRAL Working Group 5 from the outside, it's very commercially oriented. It's not like a lot of UN organs. It's not political. Issues aren't so politicized like other UN organs. They tend to be practical, tend to look at commercial and economic implications. But it's not subject to as much of the ideological conflict one might see in other UN organs. And I should also mention that the whole UNSOL process depends on a ecosystem of various actors. There are the NGOs that Chief has talked about. He focuses on INSOL, but of course, there's IBA, the International Bar Association, and American Bar Association. European Union was studying cross-border insolvency and developing its own ideas, and that was important. And then, of course, there are the academics, the professors who develop a theoretical framework for cross-border insolvency, whether it's Professor Jay Westbrook, University of Texas, or Professor Ian Fletcher from the UK. During the deliberations, of course, the US delegation played an important part in the development of the model law. But the US tried to have a delegation that had broad-ranging expertise and experience. The head of the delegation was Professor Westbrook, who I just mentioned. But they had judges and practitioners as well. And that gave the US delegation, at least as I know from the legislative guide experience, that gave the US delegation certain credibility that they had such highly experienced individuals involved in the effort. My seventh point, model law, naturally, the center of discussions was the recognition of foreign proceedings, this concept of recognition, and then we get into center of main interest, COMI. But the model law also has provides for court-to-court communication and for agreements to cooperate, what we would call protocols. And the model law is especially helpful for civil law systems where the judges have to hew very narrowly to the statute. In the common law jurisdictions, the judges feel that they have greater discretion and exercising what they call their equitable powers. My eighth point, and I'm heading towards the conclusion here, if you'll indulge me for a minute more. It's probably not a surprise development that the model law was driven by advanced countries, since most of these cross-border cases, at least during that period, involve the companies and financial institutions of the advanced countries. At least in the legislative guide project, which was subsequent to the model law, several emerging economies were fairly active in the deliberations, whether it was Colombia or Mexico, etc. Also, speaking of emerging economies and developing countries, in terms of their experience with cross-border, they're not completely, that's not a completely foreign experience for them, even historically. I know in the early 2000s, for example, in Africa, there was the famous or infamous Air Afrique case, which involved numerous jurisdictions, as I understand it. So, furthermore, it's of extreme relevance today as your African multinationals, whether they're from South Africa or Nigeria, expand their operations across the continent. Now, I do want to highlight the UNSOL. This is part of my point about the ecosystem. The UNSOL Secretariat plays a pivotal role. And for the model law experience, UNSOL was blessed to have a very forward-looking secretary, Gerald Herman, and they had excellent staff for the secretariat. And also, very relevant, the chair of the UNCITRAL Working Group 5 was Judge Wizatora from Thailand. And he was very expert and some might say masterful at developing consensus among the parties. I saw that in the legislative guide experience. Now, I touched on this briefly, but the model law does have value for the developing countries. But even if the emerging economies, developing countries, don't go the whole distance and adopt the model law with its framework for recognition of foreign proceedings, they can avail themselves of these 2 points I mentioned earlier: protocols and court-to-court communication. The use of these mechanisms could give stakeholders greater comfort with and greater confidence in cross-border insolvency cooperation. It could serve as a stepping stone to the eventual adoption of the model law. And my 11th and final point is that the chief highlighted the adoption issue of the model law and why it hasn't been more widely adopted. For one thing, I don't know how useful it is to focus on the absolute number of countries that have adopted it. I tend to look at what types of countries, what types of economies. For example, the major emerging markets, what used to be referred to as the BRICS, they basically, except for Brazil recently, haven't adopted the model law. Several years ago, I wrote an article in the International Bar Association Insolvency and Restructuring Journal, and I called it Missing BRICS, missing BRICS, in the international insolvency architecture. Chief is well aware of this. South Africa is sort of the exception that proves the rule because they had this reciprocity requirement. But I think what the chief has studied cries out for further empirical study of why more developing countries and emerging markets have not adopted the model law. I think it would be very useful for somebody, whether it's an official body or one of the NGOs, to conduct a survey of what is holding back these countries. Now, of course, as I was mentioning, it's not just the numbers of countries that adopt it that's important. Also relevant is, are they actually using the model law? Some countries have the model law on their books, but are they taking advantage of it? And one final point, since we are talking about UNCITRAL and important instruments that have come out of UNCITRAL, I think it might be useful in this area to study why and how the New York Convention on Arbitration is so widely adopted and so widely used by countries all over the world. I think there are over 160 signatories to the New York Convention. I looked it up yesterday. I think 167, 169, when you include some other types of jurisdictions. So that might be a useful basis of comparison for seeing why one instrument produced by the UNCITRAL body is widely adopted, and why the model law on cross-border insolvency isn't as widely adopted, and maybe that would offer some lessons as to how to improve the adoption rate among emerging markets and developing countries. of course, those countries and economic jurisdictions need some technical support to understand some of these issues and to become comfortable with these issues. And of course, you have to have the capacity of the judiciaries, and some of the multilaterals work on that, but there could be a more concerted focus on model law adoption. But I think the New York Law Convention on Arbitration is probably one of the most effective instruments produced by UNCITRAL over its history, especially given that hugely high adoption rate, but not just adoption rate, but the widespread use of the New York Convention. That might be an interesting model to look at when one thinks about further adoption of the UNCITRAL model law on cross-border insolvency. I could go on, but I think I'll stop right there.
Well, thank you very much, Mr. Kargman, for that. And what a nice place on which to stop. I think maybe a short answer to the model law question would be the fact that business people, before they enter into the transaction, would ask whether arbitration would go through, whether their dispute resolution would go through your courts, or whether they could go the international route. And so they would need international arbitration, and that's why the model law is so popular. Whereas no one plans for insolvency at the time when they're entering into transactions, so that the use would be different. Chief, I would afford you 1 minute, to respond to Mr. Kargman, and then we'll open up the discussion to everyone else.
Thank you so much, Stephen, for that contribution. I appreciate everything that you have said. I found the social legal approach very interesting. When you have time to look at the dissertation itself, you will see that I reviewed the works of Halliday, Coritas, Block-Lead, and many of all those, and I was able to show, why I preferred Fenimore and Sinki's norm-life theory frame. I note very much what you said about the developments in Africa in terms of businesses in Africa going cross-border. In Nigeria, we have many banks and other conglomerates going cross-border. So the issue is coming up, and we need to be prepared. There may be forum shopping. It will be really sad when we want to restructure some of these groups that we have to start going to New York or to London, etc. So there's need for us to have, a friendly insolvency regime in Africa sooner than later. And just a little bit of, I don't know how to put it, but Judge Wizutora, excellent judge. I've observed him chairing on Citra, and he's an incredible personality. But during the period of my study, 1992 to 1997, he didn't chair, but he was an observer. I think that's where he learned all the skill. And he was against the model law. That's very funny. So he was one of those that supported the other side. And his story is part of the success of INSOL in socialization. His conversion in terms of non-definition from his position as supporting the MECA to moving on to supporting the model law is part of the success of INSOL. I think I would like to leave it there, and I agree that there should be further study.
Thank you very much, Chief, and thank you to all those who have, sorry, I have two screens in front of me. One is slightly slower than the other, so you're still speaking there. Thank you to all those who have stayed. We're happy to take your questions or your comments. And while everyone gathers themselves together, perhaps I'll kick you off with a question. So we've heard about non-building, and I suppose, as Finmore and co would call it, the inter-subject agreement and how this shifts over time. I'm thinking about Africa and what Africa's role is, or what Africa's position is in the framework that has been built and continues to be built in time. And I'm wondering why it is that we should be expected to imbibe the norm that would integrate us into the global framework. Because if you look across Europe as a parallel, only very few, less than 10 European countries, or at least those within the EU, adopt the model law. What the EU has instead is the EU's directive, the framework that they have created, and it is because they could not agree harmonization of the underlying norms and values of insolvency that they have also created this procedural framework that they apply. The difference is that, or what syncs the model law and the EU's approach, is that they strive for similar or coherent interpretation of certain key concepts, such as coming. Now, when you bring it into Africa, I don't see why, or perhaps you should convince us why we should adopt the model law instead of creating an African framework that works with norms that we perhaps espouse and can agree to within Africa, such that within Africa, similar to the EU, we're responsible for the norms that we adopt and internalize. Chief, okay. And then Mr. Kargman.
Okay, thank you so much for that very interesting perspective. Just to say that with respect to Europe, the underlying values, as Mr. Kargman has said, are similar. It's just the basis of cooperation. The main difference, the way you will look at it is this, that I think that there's a Eurocentric focus. So they have the same values, which is cooperation and coordination, with some level of harmonization within Europe. Now, the only issue is that they care less about any outsider because they feel the world starts from and begins and ends in Europe. So they want to achieve the same concept of the model law within their own territory, which is Europe, because they see it as the center of the world, right? And they really don't care about the rest of the world. So when it comes to the rest of the world, they put obstacles, etc. But the values which they are propagating within Europe is based on similar concept as the UNCITRAL one. So what then happens is that the rest of the world says, okay, well, you have this nice stuff in Europe, right? We want it too, right? And so the rest of the world has it. So I think we have to be very careful when we criticize and say, we don't want this, we want to have our own because Europe has their own, right? And our own will be different. I am saying that there's not much difference between the EU regulations and what they are intending to achieve and what the model law is trying to also achieve. It's just that they close their own system, and then when it's from an outsider, then they don't want the same system necessarily to apply. And that's why they don't want to adopt the model law. So there's the power politics about it because they feel that every other thing else is irrelevant to them. They are satisfied if they are okay within Europe, right? But the reality is that at times, it's never okay. So for instance, they are fighting a war in Europe today. So they try to be okay within Europe, but then they have a war. So what we need to do is to think out of the box. As I've mentioned that, you know, in spite of everything happening, multinational companies are growing in Africa. And if we don't have a framework, if they need to do a restructuring today, they may have to go to a friendly regime, which may mean going to Europe or going to US, or now going to some Caribbean country, which again, probably controlled from Europe or America. So we need to develop our own indigenous system. That's to the extent that we need to have forum for people to restructure and do their insolvency work cross-border here without necessarily having to refer to them. Now, what will be the principles that we will use to do that? It may be exactly the same as what they are using in Europe. Thank you.
Well, this is a very interesting question and presents a challenge for policymakers across the continent, I think. But as Chief was saying, I think the economics should help drive further adoption of the model law in Africa. Now, the model law is almost universally seen as the gold standard for cooperation, an instrument for promoting cooperation. So foreign investors, when they look at the laws of a jurisdiction that they're thinking of investing in, they may well consider whether a country has adopted the model law. Colombia in South America, for example, has focused on that very issue as an impetus for them to adopt the model law. And I think one other thing when you talk about Africa is that it may be helpful for different regions within Africa, whether it's East Africa, to have all the countries, if they can, adopt the model law. I know a few of them have. Because they are trading among themselves on a very regular basis. I know OHADA adopted it for all of those countries in West and Central Africa. So that's another way to think about it. And that's where I would leave it. I think the model law would be the way to go. But as I said in my presentation, if countries are hesitant about adopting the model law and want to get their feet wet in this area of cross-border insolvency, they can use those two mechanisms within the model law, protocols and court-to-court cooperation and communication. By the way, New Zealand, when it was considering whether to adopt the model law, Justice Paul Heath wrote a very useful and substantive report considering it from an economic standpoint, the pros and cons of adopting the model law. Some of the African countries might look at that as well, that type of approach.
Okay, thank you very much to both. I suppose the underlying sense of my question was whether we could achieve the said cooperation, or why we couldn't achieve the said cooperation without going into the model law. But I would leave that for now. Is there anyone who has any question for Chief? We're slightly overrunning, so I have 2 minutes left. If there's anyone who has a pressing question or a comment to make in the space.
Could I add one thing about the UNCITRAL process?
Yes, you may.
Which is that it's a very organic process. If one goes to the UNCITRAL meetings, a lot is said during the formal sessions, but they have what they call consultation breaks, what you and I might call coffee breaks. But during those breaks, the delegates confer with one another, and that's how the consensus develops and is formed through these informal interactions. And of course, they consult with one another outside of UNCITRAL meetings. I think Chief discusses that in some of his work. But that's very important to keep in mind, that it's an organic, almost iterative process, that the work product, whether it's the model law or the legislative guide, that's how they really progress. And Chief mentioned Judge Wizard. I really meant to say he was really, I saw him in action on the legislative guide, and there he performed a really crucial role. And that's part of my larger point, that it's some of the individuals in leadership positions, whether it's the secretary of UNCITRAL or the senior staff of the UNCITRAL Working Group 5 Secretariat, or the chair of the working group, that can play a very critical role. And consensus at UNCITRAL is the name of the game. They don't take votes. So, and the chair is the one who discerns whether there is a consensus or tries to facilitate the development of a consensus. So it's a real process that the states go through in developing, whether it's the model law or the legislative guide or the subsequent products.
All right, thank you. Well, I'll have to leave it there because I think the extra 2 minutes that I have afforded us has been expired. And Chief, I see you've unmuted yourself and you have a lot more to say, but I know that we can stay here for the rest of today. I would like us to leave it here for now.
I just wanted to thank you, and thank Stephen, and thank all those that attended. I'm really honored to have Stephen discuss my presentation. Stephen, you are a great man. You are a great advocate for Africa. You know, it's really an honor to work with you. Thank you.
Thank you very much, Chief, and thank you very much, Professor. I found it very interesting.
Thank you. Well, we have a conference coming up in Abuja, Nigeria in July, where we hope that would have many more representatives from across Africa and elsewhere in the world, where they're interested in talking about this international insolvency frameworks. And so we're hoping to see several people there and to have much more useful and fruitful deliberations there. And with that, I'd like to thank everyone for joining in today, those who joined via the Zoom account, and for those who joined on our first Facebook live stream on Facebook. Thank you to everyone. As usual, I will stop recording now. Hang around a bit if you want to, put on your videos or mute yourselves and say hi to Chief Idigbe and Mr. Cargman. Thank you. Thank you both. Thank you, everyone.
Yeah, thank you, everybody, again.
Thank you.
Thank you, Chief, and thank you, Stephen.
Oh, sure. Thank
Very
you.
insightful.
Thank you.
Thank you. Thank you, Anna.
Thank you.
I hope it was helpful.
But Chief, I was surprised that after the Alan Dick case, for example, that the African countries that were involved in this conversation, say the judges, because of the way that this cross-border thing started even here, that why was there no motivation to come up with a protocol or come up with an agreement that would facilitate such types of cases in, subsequent events if they ever arose? It just died that way.
That's because if you remember that when you talk about protocol and you talk about some form of arrangement, usually I'm not talking about court-to-court protocol. I'm talking at state level. Many of these issues have to be pursued at the executive level. So like what happens in the US delegation You would have a typical academic like Professor Westbrook on the panel. You would have a judge like, Livlin and
Osmond.
Yeah, and then you would have like somebody from the government executive section, like I think Mr. Bowman.
Yes, Al Berman from the State Department.
Exactly. So when you look at the Nigerian delegation, for instance, to UNCITRAL, the only person who attends is usually some low-level diplomatic officer from the consulate who they send because they don't want to spend the money to send somebody from Nigeria, right? I don't want to go into the details. So we did campaign. We went and drew the attention of the trade ministry to the issue and said they must. The minister sent some people and we went as observers, and then our delegates were not there. But they came.
Yeah, they came. It's true of a lot of the delegations, unfortunately, that you need subject matter expertise
exactly
to be able to discuss these issues in a meaningful way. And one can't expect a embassy or consulate officer who has general issues in his portfolio to be an expert on these highly technical issues.
So, that's the problem. So you then don't have the support at the executive level of people who are sufficiently invested in this topic to engage on a state-to-state basis. And then you can imagine the judges in Nigeria to get involved with a protocol with another judge abroad. That could be mayhem in terms of the hierarchy and things like that. Who gave you the I mean, just what happened with a situation where a judge got a license under a provision of a law to come in and finish a case he was doing after being appointed to the Court of Appeal, and the Supreme Court said it was illegal or something, or the Court of Appeal, I'm not sure it's the Supreme Court, that how can you do that? But this is a country where I know that my father, when he was in the Supreme Court, simultaneously was Chief Justice of Midwest Region. Because once you're appointed a judge, you are a judge. In Canada, where I'm also licensed to practice, at times they don't have enough judges at the Court of Appeal. They have too many cases. They want to clear it. They will rent Superior Court judge to come and sit at the Court of Appeal for some time to clear the bench. Because once you're a judge, you are a judge. If they're having problems with panel, having enough judges to decide the cases, they will simply co-opt judges, because once you are a judge, you are a judge. That's why Supreme Court of America is called the High Court. They're High Court judges. So, it's just the appellate stage, right? Doing appeals, that's all. It's not that, but they are basically judges. So there are things we need to change in our attitude. We keep trying to change our history, but the history is the same. But we are trying to, because of this issue of promotion, position, power structure, and the rest. So we are missing the point. That's what I was saying.
That's what Mr. Cargman said. A look at it through the political economy framework might also serve us well when we look at how the different players are operating within that space that we have. But I have to get back to work. I wish we could do insolvency law all day. It's been nice talking to you, and I hope to see you again soon.
Thank you very much, Professor. Thank you, Chief.
Thank you. And if I could just boast a little, so Professors Westbrook and Ian Fletcher was my supervisor. So Ian Fletcher, Ron Hammer, and all those people were the people at whose feet I sat, and
they were a special group.
Yes.
That's why I say sometimes it comes down to
that's why you are very good. Yeah.
And I would say that Professor Fletcher's house is just down the road for me. I go to see his. And when he was going to pass, what he gave me were his old books. So I feel like I have some of those archives, some in some scribbles. He said, "There's